prosecution requests that Exhibit A be entered into evidence. The totality of circumstances available to Detective Sachs indicated that Mitchell had authority to consent to the search of defendant Fromholz's computer. There are two kinds of third-party authority: actual authority and apparent authority. Apparent authority can be enhanced by the totality of circumstances, which are all the facts available to officers at the time of a search.
The court's never held actual authority in the property of a roommate. That's not a fair question. I don't know what the case is saying.
What is actual
I
authority?
mean, is there really an argument for actual authority when this computer didn't belong to the witness and where this person, was just a fellow roommate of his?
No, Your Honor. Mitchell's actual authority evaporates at the door of Fromholz's room, where no common authority existed. From then on, Mitchell has apparent authority, which extends to entering the defendant's room, opening the defendant's laptop, powering it on, displaying the defendant's desktop user account on the screen, and included the logging in process, because nothing in the facts indicate that Sachs knew or should have known that the defendant changed their computer password. Furthermore, I would like to note that Mitchell resolved their ambiguous gesture by completing the login process, indicating that Mitchell knew the password necessary to sign into the defendant's computer and view their password-protected files. Detective Sachs did not need a warrant to view the files that were displayed in plain view. May I continue, Your Honor?
Please.
If neither actual authority or apparent authority are present, then a third party possesses no authority to give consent to a search, as in Trulock v. Free, 275, Fed 3rd at 391. I will be focusing on the totality of circumstances that validate Mitchell's apparent authority. Wait, actually, can you pause it really quick? Since I've already explained the shift in from actual authority to apparent authority, do I have to go over my actual authority part? Okay, that's what I was assuming.
But you have plenty of time. You've never run over really on time on this thing, but it's confusing to us, or at least to me, when we talk about actual authority, but then say like, well, he doesn't have actual authority, so that's not what we're gonna rely on. I think if you were gonna make some claim consistent with the case law that Mitchell had actual authority to consent to the search of the computer.
Common area.
Right.
Shift.
Where I understand the significance of that, notwithstanding the fact that it's not in the common area and that this is a computer that he, for whatever reason and under the case law, because I know in my brief review of the cases there, and some of the, even in the materials they talk about like, well, there's actual authority under certain scenarios and factors. So unless you are going to be able to at least make a credible case, an argument saying, no, he had actual authority. He was actually able to, because, and that was kind of what the first judge went with you, where he was like, well, that time he was talking about, well, they gave the witness the password at one point, and they never limited it, so he had access to it, and he was able to consent to a search by just because he was given the password and given permission to use the computer. So by extension, he had authority to consent to the search. I don't know if I agree with that. I don't know if you agree with that. I don't know if you feel comfortable arguing that.
I do agree with that. Can I explain to you can you ask me a question like that?
Sure, so let's try this. Was there anything about how the defendant gave the witness permission to use the computer that would give him actual authority?
Your Honor, I would like to point to the case of United States versus Aaron. Oh, yes, Your Honor. I would like to point to the case of United States versus Aaron, where there was a transfer of consent from the defendant's old computer to the defendant's new computer, simply because the defendant never advised third-party Mays not to use their new computer. In regards to our case, that underlying transfer of authority is applicable. Defendant Fromholz gave Mitchell access to their computer with an old password. Defendant Fromholz never advised Mitchell not to use their new their computer after the password change, and thus Mitchell had, is it?
I
That-
think you
that'd be
make the
what you feel
argument,
comfortable
Diana.
with. Yeah.
You make the argument, as a prosecution, you make the argument even if it's a feeble one, it's not that
Okay.
strong. And you say, but you always then say, even if he did not have actual authority, he clearly had
Okay,
apparent authority.
Yeah.
So-
Because at this point of your argument, it would be like, well, but Fromholz did change the password and didn't tell him, right?
yes, so,
And he didn't, so then wouldn't that indicate at least that he didn't want the witness to have, authority over this computer?
absent conflicting information, it was clear that Mitchell had apparent authority under the totality of circumstances available to Detective Sachs. 1. Mitchell had ready access to the defendant's bedroom, although the bedroom door was closed. As established in United States v. Andrews, whether a defendant leaves their bedroom door open or closed does not affect the consenting party's authority. Courts do examine, however, whether the defendant made an effort to block off their bedroom. However, defendant Fromholz did not take this extra step, indicating Fromholz did not have a high expectation of privacy for their bedroom and the contents within their bedroom. Secondly, it was clear to Detective Sachs that Mitchell had ready access to the defendant's computer. As Mitchell was able to promptly enter the defendant's computer password upon, as Mitchell was able to promptly enter the defendant's computer password and display the defendant's password protected files.
No,
That
he
sounds
doesn't
bad.
display the protected files, he displays the opening screen.
Oh, as Mitchell was able to promptly enter the defendant's computer password and display the defendant's desktop contents in plain view. May I continue, Your Honor?
Yes.
In United States v. Buckner, the court held that Michelle, the defendant's wife and co-inhabitant, possessed apparent authority. The totality of circumstances indicated that the totality of circumstances provided officers with the basis for an objectively reasonable belief that Michelle had authority to consent to the search of the defendant's computer hard drive. While not identical, there are significant factual similarities between the case of United States v. Buckner and People v. Fromholz. A. In both cases, each third party told searching officers that they occasionally used the defendant's computer to play games. B. In Fromholz, Mitchell told Sachs that Mitchell could get into the defendant's computer. In Buckner, officers observed that the computer was turned on with its screen contents in plain view. C. In Fromholz, Mitchell did not tell Sachs about the facts surrounding the password change. In Buckner, Michelle was unaware of password protection. D. In Fromholz, Detective Sachs took a picture of the defendant's
2 minutes.
desktop screen, but did not open files. In United States v. Buckner, officers made a copy of the defendant's computer hard drive, but did not open files. Detective Sachs' taking a photograph of the defendant's desktop screen is analogous to making a copy of a computer hard drive, as searching officers were simply saving information for later review.
What do you make of opposing counsel's argument that the detective should have done more when he was presented with the sign, the shush sign, while the witness was opening or entering the password?
Your Honor, there is a split second of ambiguity. Mitchell begins typing in the defendant's password, pauses, and holds up their index finger to indicate shh to the detective. However, immediately after this ambiguous gesture, Mitchell resolves this ambiguity by completing the login process, indicating that Mitchell had ready access to the defendant's computer. If it is reasonable to say that an officer has the obligation to clear up an ambiguous discovery, as in United States v. Purcell and United States v. Griswold, then it must also be reasonable to say the officers do not have the obligation to clear up a resolved ambiguity. May I continue, Your Honor?
Yes.
Is that reasonable? Okay. In both cases, in United States v. Buckner and People v. Fromholz, the defendants believed that they were the only people who knew the password necessary to 1. Sign into their computer, and 2. View the password-protected files that they had created. The totality of circumstances in both cases warranted searching officers of reasonable caution to believe in the consenting party's authority. Your Honor, the prosecution requests that you deny the defense's motion to suppress. The totality of circumstances support Mitchell's apparent authority to consent to the search of defendant Frankels' computer. There was no violation of the defendant's Fourth Amendment rights. Thank you, Your Honor.
I think when you get a question about the ambiguity, I think you handled it appropriately, but then you go back to this, not only like it's resolved, plus the brutality of the circumstances surrounding it.
Oh, yes. Oh, can you ask me that again really quick?
Yeah.
Are you recording this? Okay.
Okay, so counsel, the opposing counsel says that the witness made a dubious statement which belied the real truthful nature of how he got this password, and says that the officer should have done more. Is this an ambiguity that would have required more from the officer, and would it be permissible for us to ignore it?
No, Your Honor. This was not an ambiguity that required further inquiry or action from Detective Sachs. Mitchell resolved their ambiguity by completing the login process, indicating that Mitchell had ready access to the defendant's computer and the password-protected files within the defendant's computer. If it is reasonable to say that an officer has the obligation to clear up an ambiguous discovery, as in United States v. Purcell and United States v. Griswold, then it must also be reasonable to say that officers do not have the obligation to quote-unquote clear up a resolved ambiguity. Furthermore, I would like to point to the totality of circumstances in our case, which are quite similar to that of United States v. Kimwana. In United States v. Kimwana, third-party Nick told searching officers that the room he was about to consent to the search of was quote-unquote not his, an ambiguous statement. Despite this ambiguous statement, the appellate court held that the totality of circumstances provided officers with the basis for an objectively reasonable belief that Nick had authority to consent to the search of the shared hotel room. Similarly to the totality of circumstances in our case that provided Detective Sachs with the basis for an objectively reasonable belief that Mitchell had authority to consent to the search of defendant Frankels' computer. There were two clear facts. Detective Sachs was clearly aware of the following. 1. Mitchell had ready access to defendant Frankels' bedroom, despite the bedroom door being closed. As established in United States v. Andrews, whether a defendant leaves their bedroom door open or closed does not affect a consenting party's authority. However, courts do examine whether the defendant made an effort to lock off their bedroom. Defendant Frankels did not take this extra step, indicating that the defendant did not have a high expectation of privacy for their room and the contents within their room. Secondly, it was clear to Detective Sachs that Mitchell had ready access to the defendant's computer. Mitchell was able to promptly enter the defendant's password and display the defendant's desktop computer screen contents in plain view. Is that
Good.
reasonable?
So yeah, I would say, I want something to say like, look, I think I know what ambiguity means, but I don't know if I know what it means under the definition of case law. You know, like, if this is there's a million ambiguities in everyday life, right?
Mhm.
You can think two different things based on one or two set of facts. If this is the same as whatever they found as an ambiguity in Kimwana,
Exactly.
or whatever they found was an ambiguity elsewhere, like, well, it's not really my room, but you can go ahead and search it. Well, that's something he said, it affects like how he does it. This is just like it was a gesture, it's confusing, but it didn't affect the way he was able to do it. And just enabled to say like, look, so kind of like define what the ambiguities were previously. Say like, even if there is an ambiguity, it is cleared up or not cleared up, it's under the totality of the circumstances, it is still reasonable for the officers to act.
All in all, the totality of circumstances override a singular ambiguity.
Right, if that's what, I mean,
Yeah.
that's what the case law says, okay.
Mhm.
Yeah,
Okay.
so, and then you just spin it back to where you, exactly where you were. Good
Okay.
job.
Thank you.
Good job.